Well, originally, as you know, former Baltimore Ravens running back Ray Rice got a relative slap on the wrist from the NFL and apparently from the New Jersey prosecutors as well, following the release of this video. As you saw this in the Atlantic City Hotel, the Revel here, it shows Rice dragging his then fiancee out of the elevator unconscious. Rice telling the NFL that he had hit her in the elevator, but she had hit her head. There was questions about what actually preempted this and everything else. But the NFL, having seen this, said a 2-game suspension would be sufficient. And Rice, he avoided jail altogether and got probation. As we know, this week, this new video surfaced, and we all know, as the world does, what we see. Rice punching his wife in the face, knocking her out cold, then dragging her out of the elevator back. This was in May. And then at the time, the Atlantic County prosecutor, I should say in May, the prosecutor allowed Rice to enter a pretrial intervention program, and if he completes the anger management program, charges will be dropped altogether, and he won't even have a record of conviction. Well, the NFL said they never saw the video, and they had no idea, and as a consequence, when it finally did come out, they said, you're suspended indefinitely, and his team, the Ravens, in fact, released him summarily as well the same day. But New Jersey law enforcement today, and if you haven't seen it, this came out late this afternoon, a law enforcement official went to the Associated Press and say, wait a second, they sent the same video that you just saw that the NFL claimed never to have seen, they sent to the NFL executive office that same clip months ago here. And in fact, they had an audio recording of a person at the NFL office, to this point unidentified, saying, we received it and it's terrible. All right, I want to bring in our panel right now. A whole host of questions for these guys. Jim Kasuris, criminal defense attorney in Manhattan, lecturing at New York Law School, visiting professor at the University of Birmingham in England. Doug Von Oist, a founding partner of Karsten Von Oist, focusing on corporate misconduct and selected as one of the Legal 500 most influential trial attorneys in the nation's group. Mayo Bartlett, attorney, former chief of the Bias Crimes Unit in Westchester County's DA's office, and Dan Shore. He is on the board directors Ed Hope Store, the group we were just talking to our last guest about. It's a group that provides resources to survivors of domestic violence. He's also a former Yonkers Inspector General and a criminal prosecutor in Westchester County, New York City, focusing a lot on these very same issues. Okay, first off, let me just start with you, Dan. Is it conceivable to you that the Atlantic County Prosecutor's Office, who nobody debates, saw both videos, the video from her being dragged out, but also what happened in that elevator, would have just done an intervention program? I know he has no priors, but if that was your DA's office at the time when you were in there, would you have pressed for some charges or just go for some anger counseling and you know what, you'll have no record?
If you have a video of Ray Rice punching his fiancee, knocking her out, and the rest of the evidence that we saw, there is no excuse for him not to get a jail sentence. The probationary plea, or even less than that, the diversionary program, that's often done for first offenders, especially when the case isn't very weak. If the victim of the violence is not cooperative, it may be hard to build a case. But you have something that prosecutors hardly ever have. That's a video of the crime. He should be in jail, and it speaks to the larger problem of police and prosecutors not being aggressive in going after people who are abusing other people.
If the spouse, the partner, the girlfriend, whatever the case may be, the victim in this case, chooses to not press charges, I know you have the discretion to do it, but do you really have the case to move forward if you don't have a willing person to press those charges?
Absolutely, and I've tried a lot of those cases for a couple of reasons. First of all, the survivor, the victim of violence, we don't know what pressure she's under to say that she doesn't want to go forward. Maybe she's being threatened. Maybe it's the emotional or economic pressure. Second of all, the person who committed the violence is a public safety threat, not just to that person, but to future people they may be in dating and marriage situations with. So for society and future potential victims, you have to be aggressive.
So you can do it, and they should have done more with it. And now you have Mayo. Apparently, you've got elected officials, including the Senate Majority Leader in New Jersey, asking for officials above and beyond the Atlantic County Prosecutor's Office to take a look at this. What can they do once this thing's been adjudicated already?
I don't see that there's very much that can be done, and it doesn't rise to the level of a federal offense. And also, when you stop and you look at whether the victim wants to go forward, that's a huge component of the case, because unless you can show that Ray Rice did something to prevent her from coming to court, I don't see how you get all the rest of this information in, because it's not subject to cross-examination. Now, in New York, you'd have what's called a SIRA hearing under People v. Cotto, and there, basically, if you can show that the defendant took some steps to intimidate the victim, maybe threatened the victim, prevented the victim from coming forward, you can use grand jury testimony, other information. We tried a case like that when I was in the DA's office, where a person's car was firebombed as a message to tell them basically don't come forward and testify. But other than that, you really still have to afford a person innocence until proven guilty. They have a right to put on a defense, and if you can't question the victim, you're really denied that right.
But you got that video,
But
right?
you don't, the video shows the crime. Now, Ray Rice can say there's some other facts that we don't know about. I can't imagine what they would be seeing that video, but the video is powerful evidence. When I was a prosecutor, I would have loved to have had video evidence of crimes, and you hardly ever get that, but here you do. So prosecutors don't need cooperative witnesses other than the videotape and other people who saw the aftermath of the scuffle.
Let me ask you, Jimmy, how much of this matters that it was an NFL player in the NFL, okay? Because do prosecutors, whether they want to admit it or not, or DA's offices say, you know what, I don't really feel like taking down the NFL, the shield and the brand here. This isn't like Joe Schmo, you know, from down the block. How does that, if at all, impact how they move forward on this? And we'll talk about the NFL themselves in a second.
Well, the NFL is a completely different story. I mean, clearly what they did here was to look the other way in order to keep this fella on the field. But I think it does matter. I think when you're a public figure and you know you have fans and so on and so forth, sometimes prosecutors' offices become a fan. But you know the bigger issue here is these programs to begin with. It's true. The programs are given if you're a first offender and if you don't have a great case, if your victim doesn't want to come forward. I have a problem with the programs, period. Because somebody, you know,
and apparently, I want you to answer that.
Sure.
Apparently, there was some questions as to how this was initially handled, because there wasn't a victim's advocate that was even there present. So nobody, you know, they got a person who was knocked out. Husband's the breadwinner in the family, and all the other things that go on with abuse that our last guest so articulately spoke to. Apparently, they didn't afford her that, which they said is important in this process.
Of course, it's important in the process. I mean, these programs are good for information. It is my view that they don't really cure the recidivism. I don't think that studies show that these programs with respect to domestic violence actually prevent these people from doing it again. I think they're great programs. They should have them while you're in jail, serving 30, 60, 90 days on your first offense and getting into these programs. This isn't an addiction. These people aren't beating up their bosses. They're not beating up their lawyers. They're beating up the women that they're with.
Yep.
This is not like a drug addiction, a substance abuse problem, a gambling problem. I'm
Jimmy,
not so
because
sure
the time
that this is the answer.
I want to get this part from you, and then I want to get Doug in a couple things, which is the league and the Ravens said, we never saw the video. We asked for it. The prosecutors, now we know that at least one of them saying, hey, we did provide it. We didn't have to. We chose to because we knew they were going to do a review for the punishment. First of all, whether or not the prosecutors wanted to, the security teams for the NFL, they're former FBI agents and everything else. If they wanted to get the video, they could have got the video, right?
You know that. But the fact is, okay, if they were negligent and didn't get it because they didn't want to get it, that's one discussion. But to have it, to have seen it, to have lied about it, and to have handed out a punishment based on not having seen it, based on that lie, is reprehensible. It is reprehensible, and it says an awful lot about how the NFL looks at these types of situations.
All right, we're going to take a quick break. We're going to extend this conversation to the other side. When we come back, I'm going to put Doug in the barrel because I want to know a couple things. One is the NFL decided to CYA, and you know where I'm going with that. Did Ray Rice get double jeopardy here in any chance? And what if it wasn't an NFL player? What if it was an attorney? What if it was a cop? What if it was you that was in that elevator? How would you have been treated differently from the law? And would you still have your job today? We'll get into that after this.